Hello everyone, this is Carla de la Rosa-King, immigration attorney, and today I want to talk to you briefly about a frequently asked question. The question is, if I enter the United States in a tourist visa and then I overstay my visa and later fall in love and marry a lawful permanent resident, can I adjust status through marriage to that lawful permanent resident? The answer to that question is no. If you enter on a tourist visa and overstay your visa, that means that you are no longer on valid status. So if you are no longer on valid status, you are not going to be able to file for adjustment of status based on marriage to a lawful permanent resident. If you are in this situation, you have a few options. The first option is to simply wait until your lawful permanent resident spouse becomes a U.S. citizen, and once this happens, then you can file the one-step application. You can file everything at the same time. Your spouse will be able to file the I-130 petition for alien relative on your behalf, and you'll be able to file for the application to adjust status. The other option is for your lawful permanent resident spouse to start the process by filing an I-130 petition for alien relative on your behalf, but only the I-130 petition. You are not going to be able to file the adjustment of status application because remember that you already overstayed your visa, therefore you are not in valid status, so you don't qualify for that adjustment of status while your spouse is still a lawful permanent resident. So if you decide to go this route, your spouse will file the I-130 petition on your behalf, and then once he becomes a U.S. citizen, then you are going to notify USCIS that your lawful permanent resident spouse already became a U.S. citizen. So you are going to ask them or ask them to upgrade your petition, and at that point in time, you're going to be able to file for the adjustment of a status application and the application for employment authorization document. And the other option, I see it when, for example, the lawful permanent resident spouse do not want to become a U.S. citizen, or they simply don't qualify for citizenship. So if that's your situation, then you are going to have to apply for the provisional waiver, depending on the amount of time that you have overstayed your visa. If you have already overstayed for so long that you're already subject to the 3 or 10-year bar, then you need to file for the provisional waiver. Of course, you'll file for that provisional waiver while you are in the United States, and then once that waiver is approved, and you are scheduled for your interview at the U.S. Embassy or consulate, then you are going to have to leave the United States to apply for that immigrant visa at the U.S. Embassy or consulate. So if you're in this situation or you have any question about this matter, and you would like to discuss your case with me, please feel free to give us a call at 773-366-1214. Thank you.